All right, let's get into it. Today, we are breaking down a piece of law that is absolutely shaking up the world of artificial intelligence, the EU AI Act. And look, don't make the mistake of thinking this is just some European issue. Its rules are designed to reach across the globe, and that can mean they affect your business, no matter where you are. So let's dive in. So let's just cut right to the chase with the question on everyone's mind outside of the EU. If your company is building or using AI in, say, Sydney or maybe San Francisco, do you really have to care about a law that was passed all the way over in Brussels? And the answer is a huge, unambiguous yes. This is probably the first and most important thing you need to get your head around. The AI Act has what's called extraterritorial reach. What does that mean? Well, simply put, if the output from your AI, the predictions it makes, the content it creates, if that stuff gets used inside the European Union, then you're on the hook. Your physical location won't protect you. Okay, so let's really dig into that first most fundamental question. Who exactly is this law actually for? So the Act obviously covers all the usual suspects inside the EU. We're talking about providers, users, distributors, no surprises there. But the real kicker, the part with global teeth, is that very last point. If you provide an AI service from Australia and your client in, say, Germany uses it, boom, your company is now under the authority of this law. And that's the first major roadblock for any international business that thought this was just a Europe problem. Now, it's not a total free-for-all. There are some very clear exemptions. The Act basically gives a pass to AI used strictly for military or national security. Same goes for pure scientific R&D. And maybe most importantly for a lot of people, if you're just messing around with an AI tool for your own personal, non-work stuff, you're totally in the clear. It really helps show you where the regulators are aiming their focus, on AI used in a professional, commercial setting. Okay, so let's say the law does apply to you. Your very next step is to figure out your risk level. The entire AI Act is built around this idea, and this is where we're going to find the biggest red flags and the toughest roadblocks for your business. The Act sorts every AI system into one of 4 buckets. Down at the bottom, you've got minimal risk. Think spam filters or AI in video games. Pretty much no special rules apply there. A step up from that is limited risk, things like chatbots, which really just need to be upfront that they're not human. But the real action and the real trouble starts at the top 2 tiers, high-risk systems and the unacceptable risk category, which is just banned completely. Let's start with the biggest red flag of them all. Article 5 lists out practices that are just considered an unacceptable threat to our fundamental rights. And these aren't just discouraged, they are flat out prohibited. No ifs, ands, or buts. We're talking about things like government-run social scoring, using emotion recognition tech at work or in schools, or AI that's designed to manipulate you into doing something harmful. If your AI does any of this, it is a complete non-starter. For most legitimate businesses, though, the single biggest and most complicated roadblock is going to be this: trying to figure out if your AI system falls into that high-risk category. This is where the compliance burden gets incredibly heavy. And honestly, figuring out if you belong here isn't always cut and dry. So how do you even know if your AI is considered high risk? Well, Article 6 gives us 2 main pathways. The first one is pretty straightforward. If your AI is a safety part in a product that's already regulated by the EU, like cars or medical devices, then it's high risk. The second path, this Annex 3, is a list of very specific, sensitive areas where AI could have a huge impact on someone's life. Think employment, education, law enforcement, anything that touches on fundamental rights. Right, so let's say you've done the work and you've determined your system is high risk. This is the point where those roadblocks we talked about start to feel more like concrete walls. Let's get into the really serious obligations that come with that high-risk label. Okay. The absolute biggest roadblock for any high-risk AI provider is something called the conformity assessment. Before you can even think about going to market, you have to prove that you comply with the rules. This process really forces you to answer 3 critical questions. 1, is this thing actually an AI system by the official definition? 2, is it high risk based on those 2 paths we just talked about? And 3, Who is the provider? Which person or company is legally responsible for getting this assessment right? And in case you're wondering why it's so important to navigate these roadblocks correctly, well, here's your answer. 35 million euros, or 7% of your company's global annual revenue. And here's the key part, whichever is higher. That's the maximum fine for the worst violations, like using a banned AI. I mean, that's a number that's pretty much impossible to ignore. So we've laid out the risks, we've seen the stakes. Now let's pivot and talk about the practical stuff, the implementation issues. What does a real-world compliance to-do list actually look like? If you have a high-risk AI system, your entire way of working has to be built around these 7 requirements. This isn't just a checklist you tick off at the very end. It's a fundamental change to your process. You need a system for constant risk management. You need solid data governance to fight bias. You have to keep meticulous technical documentation and logs to prove everything. And the system itself has to be transparent, have a real human in the loop, and be tough enough to withstand cyber attacks. These are the core hurdles you have to clear. So let's make this super practical. What should our Australian company do, like, right now? Here's their actionable checklist. First, they have to appoint a representative based in the EU. Next, they've got to go through that tough conformity assessment we talked about. Once they pass, they get to put that little CE mark on their product. Then, they need to set up a system to keep an eye on how it's performing out in the real world. And finally, they have to register their system in a public EU database. That is the step-by-step path to being compliant. The bottom line is the EU AI Act has set a brand new global benchmark for artificial intelligence. Its rules have effectively erased borders, which means compliance isn't really optional anymore for any company with global ambitions. The EU has drawn its line in the sand, so the only real question left is your AI ready?